All right, welcome back to Double Fries No Slaw. Been a long time, but we've got our favorite attorney back on with us, Doug Rohan of Rohan Law. Going to talk a little bit about this NIL, Leonard Hamilton, FSU saga, and then maybe throw in a little ACC talk at the very end too. We've had some questions, and so we'll try and update you there. So for all of your legal needs, we've got Doug Rohan back to chat with us again. Doug, how you doing, bud?
I'm doing great here from sunny Florida, spending some time out on 30A with the family for New Year's. So figured I'd take a few moments out of the college football bowl season afternoon to sit down and chat with you about what's been going on.
Yeah, I don't know if it's more impressive that you're breaking away from vacation or breaking away from bowl season, but either way, we appreciate you for hanging out. It's been too long. Obviously, a lot of stuff slowed down there in the season, but we're glad you're back with us, man.
Happy to do it. And we've been very straightforward with the fan base and the viewers. We're not going to bore you. We're not going to sit here and just keep spoon feeding just dumb stuff at you. There wasn't a reason for us to get together. So unfortunately, Florida State and Leonard Hamilton changed that in the last 24 hours. So we figured we'd hop back on and chat about some updates.
Yep, I was laying in bed yesterday because my kids were had slept in for the one day of the break that they do that, and at 8 a.m. I see the tweet from Ross Dellinger, and I'm like, oh no, like what are we doing again? So, all right, let's talk about it. Some former players at FSU, some former hoops players suing Leonard Hamilton for a few
Mhm.
different things. We talked about this with the ACC. It's not just one assertion, not just one claim. There are
Mhm.
four that we'll talk about here today. But can you give us a kind of a high overview, and then we'll dive into some of this?
Sure. Well, first off, we're talking about players, starters from last year's team: Darian Green, Josh Nickelberry, Primo Spears, Cameron Fletcher, Deontay Green, and Jalen Worley. These were players that were playing substantial time, and there were transfers that we encouraged. And that's what we're going to really get into at this litigation to transfer to and start with and stick with Florida State for the 23-24 season. And according to the allegations, an attorney has come alongside these players and are suing Leonard Hamilton personally and individually. And that's one of the things we're going to get into in a minute. But basically, for breach of contract, saying that Hamilton had promised $250,000 in NIL revenue to each of these players. And at the end of the day, nothing was ever paid to them. It came to a head right before the Duke game last year, where the players staged a walkout of the practice. Coach Hamilton got them all together in the film room and promised them that the money was forthcoming, and so and got everybody back onto the court for the Duke game. And we saw how the team finished out last year, despite being on the cusp of perhaps making one of the top four teams entering the playoffs for the ACC tournament. They kind of couldn't put it together towards the end of the season, and that's really probably largely due to this off court stuff that was happening. So this is a big deal. This is not nothing. Unfortunately, it is, the rising spear that's back in the news, not the battle's end. So for those that think that, all the collectives tied together and are the same thing, this is not dealing with the battle's end. This is the rising spear, which is the same crew that we had, unfortunately, the problems with the Amarius Mims action. And basically, they're suing Coach Hamilton for not only the $250,000, but now damages and some additional funds. So we're going to see, as we saw in the ACC litigation that we guided you through, what is for real and what is just bluster. And we have some big questions that we're going to tackle in this video about what's going to happen next.
So maybe the biggest point that we can talk about with this is Florida State not named in this,
Mhm.
and you know why, but can you explain why Florida State not named in the lawsuit?
Sure, that's the first big issue that needs to be addressed. Florida State is not included in the litigation specifically, and we saw this in the ACC litigation that we've talked about because of the immunity provisions. Florida State and their coaches and their teachers and instructors and administrators all have immunity against tort litigation. That's one thing the ACC is fighting over in the litigation with the Florida State Board of Trustees. So the attorney that's representing these five players has to go after Coach Hamilton individually. Now, the allegation is that there was a breach of contract, promissory estoppel, fraudulent inducement, negligent misrepresentations, and we'll get into what each one of those means. But what the allegation is that Coach Hamilton, Leonard Hamilton, stepped out of his coaching roles and coaching duties to make these promises about what NIL funds would be available. And that is an interesting question that we need to address. Is a coach who's by NCAA rules not supposed to be making any promises, is not supposed to be inducing players to transfer, is he then breaking that immunity provision by acting individually to make these promises to these players? Now, he's doing it on campus. He's doing it in meetings. He's doing it while he's formally traveling for Florida State. So I think that's going to be the first issue for a motion for summary judgment as this litigation drags out over the next few months and years. But do the actions of Coach Hamilton individually violate enough rules and provisions of the university and of the NCAA that a valid claim can be made that he was acting as Leonard Hamilton individually instead of as an officer or representative of Florida State?
I want to ask you in a moment just about other people named or not named in this. Obviously, it's just Leonard Hamilton at this moment. But let's talk about the actual allegations, the things you talked about: breach of contract, promissory estoppel, fraudulent inducement, and negligent misrepresentation claims. Let's talk about each one of those just quickly.
So a breach of contract requires there to be first a contract. And this was the first thing that came out yesterday in the tweets as well. Was there anything written? All we're seeing is some tweets. There are actual tweets made a part of this complaint, which I thought was very interesting. You can see the actual communications that are going back and forth. And let me be very clear. A contract does not require a written instrument. All a contract requires is a promise to do something, an offer, an acceptance that you're going to accept that person doing something, and then consideration. That's where there is a question of whether tweets or texts are going to be enough on the breach of contract issue. But that's why you have all these other layers. Promissory estoppel, what you're saying there is, okay, maybe we didn't have a formal contract, but you told me that you were going to do something, and in exchange, I did something. And by me doing something, that was enough to create a promise. I created a reasonable reliance on you fulfilling what you said you were going to do. So when Coach Hamilton, facing a mutiny right before the Duke game, says, look, guys, come on, really, I'm going to get this money for you next week. Come on, let's go ahead and play. Let's go ahead and move forward. The argument from the player side is that was the promise. That was the estoppel. They participated in exchange for the promise they were going to get paid. Now, this creates a sticky situation because once you sign up to play for Florida State, once you sign on the dotted line to say you're going to participate, the NIL is not supposed to have any bearing or impact on whether or not you play or your performance or how you perform. So while this does create a nasty black eye for the university and for the NIL collective in terms of Rising Spear and Coach Hamilton individually, there's an argument that says, I don't care what you were promised. You signed up to play Florida State basketball. You need to play Florida State basketball. So there is a little bit of question in those two sides. Same things with fraudulent inducement. The idea there is Coach Hamilton knew there was no money, lied about there being money. That's going to be a big issue. That's going to be part of discovery. Negligent misrepresentation likewise says you shouldn't have said we're going to pay you. And that's one of the things that really frustrated the players in their complaints and in their text messages. All they're saying is, look, we got rent to pay. We got taxes due. It's very eye-opening insight onto the reality of the finances of being a student athlete now. When you're getting paid money, when you're getting paid last year for NIL, guess what? You've got to pay taxes this year. Well, typically the way businesses and entrepreneurs pay this year's taxes is from this year's income. So you withhold $250,000 from players who thought they were going to get that money to pay this year's taxes. Now they've still got last year's tax bill. They just don't have any money to pay those tax bills this year. So it's really fascinating to peel the layers back and to take a look at what's going on. But this is not a slam dunk either. There are some significant legal hurdles still to overcome.
Yeah, if we look at each one of those, when you talk about the breach of contract, obviously people that you saw immediate, like, oh, well, if you didn't write it down, then you're out of luck. That's not necessarily the case, as you just said. Like the verbal contract is still a thing, but does it become so much a case of he said, she said, or he said in this case? Like, how do you really prove that if it's not in a text message anywhere. There were obviously text messages where the
Mhm.
players would ask about it, and Coach Ham specifically said, "I'll call you," right, which is probably a good
Mhm.
move on his part when you're dealing with any of this stuff. Like how does someone rule that? Like, is it a you have to
Mhm.
know beyond a shadow of a doubt? Is this a situation where it's just more likely than not? Like, how do you even try and figure that part of it out?
Well, there's two parts to this that I would delve into and discuss. The first of which is, again, a reminder that we're just suing Leonard Hamilton and not including Rising Spear. I think that's a curious legal choice. But then the allegation and the complaint is that the representative of Rising Spear is in these meetings, is listening as Coach Hamilton is verbally making these promises, saying the money is coming. That's the opportunity for the Rising Spear representative to step forward in the meeting and say, whoa, whoa, time out. We never said that. We weren't trying to do that. We're not going to try and put together $250,000 for each one of you. That's something that could have been said. So in his silence, in his lack of objection, he's basically going along with it. He's basically agreeing with it. So that's one thing that's going to be part of the discovery process, depositions, who said what did they say? And now in the text messages, the Rising Spirit representative is saying, look, maybe I can get you 10. That's a big indictment on the situation there with the collective. You're promised $250,000 and they're scratching and clawing to maybe get 10. That's a problem. But in those text messages, there is some allegation or there is some claim by the Rising Spear that we're going to get the money. Yes, we're trying to get the money. We're talking to the boosters. We're talking to people. Not once, at least in the complaint, did we see text messages saying, there's no way we can pay that. There's no way we're going to get you this money. So that's where the problem comes in this situation.
The fraudulent inducement, the idea that he knew that there was no money or knew that what it sounds like, and I don't want to assume too much here. It sounds like there was money that was maybe promised, money that they thought would come through and it never did. And they're trying to, hound people and get people to get the money to pay the guys. It does look like from the text, there was an effort to get the money. If money was promised and then not delivered to, Rising Spear or Leonard Hamilton or eventually get to the player's hands, that maybe the fraudulent side is one that to me as a, non-legal eyes, it doesn't feel as fraudulent because it does seem like there was some effort put forward. And even that is included in the text, but it doesn't seem to me like Leonard Hamilton induced them without an intent to pay. Now, I don't know what his heart was. I don't know, but nobody can read that. But it does seem like that's maybe one of the weaker sides. I don't know what your take is there.
As an attorney, I never make promises to my clients. I never promise my work accident clients we're going to get X number of dollars. I never promise my criminal clients I'm going to keep you out of jail. I'm going to get these charges dismissed. We don't make promises, but we do want to lay out what we hope to see. What's the strategy? What's the goal? And one of the very important things that I have to do is to make sure my client hears me. I might say something. Oh, I don't think that you're going to have any risk of going to jail. Well, what my client hears is I'm not going to jail. So there's always and this happens in relationships too. In marital counseling, we called it the pink megaphone and the blue microphone, or vice versa, the blue megaphone and the pink microphone. What you say and what you hear can be different things. The text messages. And that's why, as an attorney, I love this era of text messaging and everything is written out. It removes that confusion. And in the initial text messages that we see allegedly from Coach Hamilton, he's saying, I'm going to get you in the range of 200 to 250. That's different than saying, man, I don't know what we can get you. I'm not sure what's going to happen. I'm not sure, I'm going to try to get you something 200 to 250. No, he makes a very definitive statement. And God bless Leonard Hamilton. He's put in his time. I'm not here to say that, he's a bad person. This is an example of somebody who's probably tired. We saw Jim Larinaga throw up his hands this week and say, I'm out. There is a scenario in which these older coaches who have been doing this for decades have simply run out of real estate and run out of enough of an understanding to appreciate what the modern collegiate athletics landscape looks like. And they probably should have agreed to have Coach Hamilton hang it up last year. We certainly think that this is his last year. I think that's been the fans' perspective anyway. I don't know. I haven't talked to anybody on the administration, but this is yet another example of how you can't be saying these things. Even with a toothless and feckless NCAA, it is very clear from this complaint that has nothing to do with NCAA violations yet, is rife and is full of evidence that could be used to help even a toothless NCAA bring yet more pain on Florida State for misbehaving when it comes to this NIL landscape.
Yeah, you wrote this, but at worst, it's just a black eye on NIL at Florida State again, unfortunately. Like, neither one of us are happy about that. But yeah, like, if a lot comes out in discovery, if a lot is said, like, some people are going to have to defend what they've done, defend what they haven't done, defend what they've said, defend what they've promised, whatever, right? Like, whomever is called into this. And that is, by defending themselves, they're going to have to expose what's happened in front of the NCAA. Now, what is the NCAA able to do right now with their kind of NIL pause that they've got going on right now? I mean, I don't know the answer to that. But when you lay it all out there for them, it makes it pretty, it makes their job a lot easier, I would think. And so
we know tampering is happening. We know it. We hear about it. We hear whispers. Coaches are mentioning it. We know it's happening. But when the text messages are published as part of a complaint in an unrelated lawsuit, that's when the NCAA kind of gets painted in a corner and says, well, I have to do something.
I assume, again, maybe shouldn't just ask you, just like we got with the ACC FSU stuff, we will very likely now get some kind of a response from Leonard Hamilton's representation in this. And essentially that should be, now this was obviously, like we talked about again with the ACC and FSU, you write this thing showing yourself as the albatross of good, right? Like, we have done nothing wrong on our side. We are completely, in the right here. And so all we've heard is all the accusations against Leonard Hamilton. Now, we will eventually get from his representation, I would assume, his side of the story. Like, that will be something that comes to light.
Yes, there will be an answer. I don't know what that answer is going to be other than to try to win on technical merits. The evidence so far is pretty damning. What's he going to say? I didn't promise it. Those aren't my text messages. Those are fabricated text messages. The winning strategy and what I think the answer is largely going to address is maybe this happened, maybe it didn't happen, but it doesn't matter because as an employee of Florida State, I have immunity. And you can't sue me, and there's no jurisdictional basis for this suit to proceed, and this matter should be dismissed by the court out of hand. That's what I suspect to be the procedural approach of any defense in this suit, and frankly, a very strong position to take. I think that it's going to be a very hard hurdle for the plaintiffs to overcome to say Coach Hamilton went rogue. This is happening all across America with all of the coaches. This is very much well within their expected roles and their expected activities. And I don't think ultimately, and maybe I'll be wrong, but I don't think ultimately that a judge is going to agree that Coach Hamilton went so far afield of his responsibilities that he's going to be responsible, or that he's has to pay back these damages or has to pay this money.
We talked about Florida State not being mentioned in this. Does it surprise you that the suit didn't include a Rising Spear specifically?
It does, and I'm not sure why. I'm not sure what the strategic thought process was, because the Rising Spear is not a Florida State entity. I don't know practicing law. This is outside my scope of practice. I've mentioned here I do criminal defense, work accidents. Maybe there's a statutory basis for excluding them as a corporation. Normally, as a general rule, attorneys don't like to go after individuals. There's just too many problems, not the least of which is typically bankruptcy. In this particular case, we know Coach Hamilton has been coaching at a high level for many, many years, likely has sufficient assets to cover any judgment in a complaint like this. So bankruptcy is not really likely to protect him in this scenario. But you want to go after the companies. You want to go after the companies with money. You want to go after the companies with money and insurance. Perhaps an asset search revealed, and this lawsuit is because Rising Spear has effectively dried up and doesn't have anything. I don't know that to be the case. I don't have any inside information, but that's one thing I could conceive of. That they didn't want to waste their time. They didn't want to muddy the waters. But when you have a immunity defense, you usually want to have more than one party that you're going after, so that if you lose on the immunity, you're not still wasting your time. You have somebody else, another party to go after. Even if you just get a judgment on paper and you never see a dime, there's still some value in that to the attorneys and to the plaintiffs, because you can then keep that as a method for suppressing the resurgence of Rising Spear at some point in the future. If Rising Spear gets any more assets and they have a judgment against them, then they would be forced to pay that at some point down the road. But here, with them just going after Coach Hamilton, they have a high risk of not collecting anything.
I want to ask you about the ACC too, but anything else on this that you want to point out or talk about before we kind of move to some other stuff?
I really am curious to see if this is the kind of thing where maybe Florida State does step in and work with Coach Hamilton to try to resolve this on a quiet basis. Obviously, there's been communication in the past in back channels to see if this case is going to get resolved by some kind of agreement. All the players at this point have moved on to their new university or have exhausted their eligibility. So I would have thought that if there was some kind of settlement to be had, they would have already had that conversation. But it might be that Hamilton's attorneys are digging their heels in on this immunity provision and never offered anything. In which case, yeah, just like the ACC FSU litigation, we're going to get into some long, drawn-out procedural questions and then follow that up with some discovery. And that discovery might get sloppy in terms of NCAA issues down the road.
Yeah, it's just, you remember the Rashada thing at UF where he sued Napier and everybody involved with it. He actually named several people in that lawsuit. But that was like $8 million, right? It was a little surprising to me that $1.5 million is a lot for me or you, but we talked about Coach Ham. We talked about, the resources that Florida State has. I don't know what Rising Spear still has. It's a little surprising to me that this wasn't just settled quietly to not have this go away. Again, $1.5 million is a lot to maybe us or people listening, but in the grand scheme, it seemed like, man, if you could have settled this for $1 million even, right? And said like, hey, we'll keep it out of court. Let's keep it out of the news. Let's just settle and move on. And even if it was the full $1.5 million, it feels like, now again, it's not my money, so I'm spending other people's money at this moment, but it feels like that might have been the smarter move than to have this come out, unless, like you just said, unless they really feel like, hey, the black eye is worth it. Florida State knew about that. I've been told Florida State knew about this. Obviously, Coach Ham knew about this because it's been made pretty apparent that there were attempts to try and resolve before litigation happened, which is not, uncommon, as you've said. And so I guess, maybe they feel like the black eye is worth the million, like, hey, we'd rather the black eye than pay the $1.5 million. But I don't know, it being their second kind of NIL mishap or misstep, it's a little interesting to me that they didn't just settle already, unless they just feel really, really solid about winning.
Let me draw a distinction between this and the Rashada situation also. Rashada just wanted out of his agreement so that he could go to another university and get paid by that other university. Yeah, I was promised $8 million. They failed to pony up the $8 million. Well, a jury's going to sit there and if it ever gets that far, which it won't, they'll say, well, $8 million is ridiculous. You should have known that was never going to actually happen. Here, you have players that played the season. They played the season because they told they were going to get paid, and they were told they were going to get paid a relatively reasonable amount. The danger zone here is that if they don't maintain the immunity provision, absolutely, I could see Hamilton being responsible for not only this, but damages on top of that, whatever those tax late payment penalties were, any other causes or damages because they didn't have the money on hand. If they can pierce the immunity provisions, this is a viable suit with some value to it.
Let's talk about the ACC a little bit. Matt Baker had a little bit of an update today. Nothing real huge, but because we have kind of covered it and kept it updated, I'll pull this up and we'll talk about it. But two minor ACC legal updates. Number one, he said that Florida's First District Court of Appeal upheld a trial court's denial of the ACC's motion to stay the case. The ACC wanted stuff to pause. The judge disagreed. And then number two, the Florida's First District Court of Appeal also denied FSU's motion to dismiss an ACC appeal. Any major thoughts from any of that, or we just kind of drudge on?
Well, what it means is that things are proceeding basically as fast as possible. As fast as possible is still a glacial pace. I've always said that I think you and I are going to be talking a lot more over the next few weeks about this issue because we're coming up on the deadline for ESPN February 1st to decide if they want to move forward with the ACC contract. So these are important boxes to check. These are important steps to overcome, and the Court of Appeals has decided we're not going to slow this down. We're not going to do what the ACC wanted. We are going to continue moving forward in Florida. It's just going to be another week, several weeks or months before we get to the next step, which is resuming discovery in Judge Cooper's courtroom on the Florida case. The North Carolina Court of Appeals is still waiting on a decision for the North Carolina case, the appeal to the North Carolina Supreme Court. We've got a new judge taking over January 1st in North Carolina Business Court handling this lawsuit. So North Carolina case is frozen. Florida case is not frozen, but Florida case is still moving at a much slower speed than all of us would like, and I think is going to be irrelevant and moot based on what the ACC and ESPN are going to be in negotiations for here in January.
We got a lot of questions on this, and I didn't know that it was make its own video worthy. But recently, and we talked about this off air, recently asked about it out in Vegas, both Michael Alford and Drew Weatherford, Board of Trustees member and the former FSU quarterback, were asked about the relationship with the ACC, trying to get out of the ACC, just where they were. Did they still want to move this, that, and the other? And they both kind of gave maybe a little softer answers than we'd heard in the past, whether at Board of Trustees meetings or in other media type settings from Alford. They both kind of said like, hey, we're still in the ACC. We're still evaluating all options. Alfred said we never wanted to leave the ACC, and people kind of took that as, are they retracted? Like what's going on here? I don't know if you have a thought on that, or what you would share on just some statements from them, nothing legal that happened, but just some statements from them that gave people pause.
Look, I'm a big fan of both of them, big fan of Alford's and a big fan of Weatherford's. I wouldn't go so far as to say it was disingenuous to try to walk back the statements. I think two things can be true at the same time. I think that it is both true that Florida State filed their litigation because the status quo was unsustainable. And I think it is also true that now that we are in a litigious posture with the ACC, if the ACC came back and said, look, one possible solution is to not have equal revenue sharing, that FSU would be willing to listen and would be willing to stay. Again, I don't know. I don't have any inside information. I'm not talking to anybody on the inside. I don't think more than three people could really say, what the answer to that question is. I'm just kind of looking at the same information that everybody else has and everybody else sees around. Some of the people were, pointing to the original complaint where Florida State was asking if the judge would relate back, the notice to depart the ACC was as of that Board of Trustees meeting. You and I said on our second or third video that was basically one of the weakest arguments in the complaint. I would even characterize it as a throwaway line. It was something that was funny to put in there. It was cute to put in there. But there was no way a judge would, finding in favor of Florida State, also then say, and I'm going to relate back this notice to 2023. So that was never really a valid legal argument. So it could be true. It could be a way to say Alford was correct in that we wanted to file the lawsuit. But remember, this was a declaratory judgment action where you're asking the judge to decide if Florida State is to breach the contract, what would this look like? So from the first filing, from the mechanism that Florida State used, they weren't actually departing. They weren't actually announcing their departure from the conference. So that does leave open the very real possibility that a solution to this litigation is simply a modification of those payments, of how that revenue is distributed, and then FSU continues with the ACC. Now, we haven't talked a lot this season, largely because the season has been such a crater job of our team in terms of wins. There's no question that this has weakened the FSU brand, but I also think that this is the new landscape of college football. We're going to see these ups and downs every year from teams. I mean, you were watching the Alabama game. I don't know what the current score is, if Michigan is going to do the Lord's work for us this afternoon, but you're not going to have decades of dominance or 5 straight years of college football championship playoff finals like we have in the past. We're going to be having ups and downs every season with every teams. And at the end of the day, we still had the eyeballs. That's what mattered at the end of the season. As awful as Florida State was, we still had the eyeballs.
Michigan just dropped an interception that would have sealed it, and so Bama's probably going to go win it at this point. But the viewers will know once they watch. Doug, where can people get more of your updates on this? I know you do a good job on Twitter, and then tell us a little bit about Rohan Law.
Yes, please do follow us, Rohan Law PC, on Twitter or any social media that you follow. But I'm most active with the Florida State side on Twitter. I can't stop myself from fighting with perfect strangers about my passion for Florida State football and X. But do follow us on all the other social media as well. You can learn about our firm out of Atlanta, Georgia, where we do handle criminal defense and we do handle work accidents. And if you need help finding somebody, I've had several of your viewers reach out to me with cases in Arkansas, Alabama, North Carolina, Florida. Maybe they just didn't know how to find an attorney or how to find a good attorney for their accident case, and we were able to help broker them with a competent and capable attorney that was one of our friends in our referral network. So if you ever have any trouble, if you ever find yourself in a difficult spot, we say we want to be your best friends on your worst day. If you want to talk to a Nole about what's going on in your life, let us know, and we'd be happy to help you out. And if we can't help you, we'll point you in the right direction.
Awesome, man. Well, we appreciate you for your time. Appreciate you for chatting with us. We'll get you back on here soon as more and more happens with the ACC. If anything happens with Hamilton, maybe we can do that too if people are interested in it. But man, we appreciate you so much for breaking away from vacation to chat with us.
Happy New Year. Take care.
Everybody. Go Noles.